When I was in primary school, one of the highlights of the year involved the Coca-Cola yo-yo experts. They'd perform all sorts of amazing yo-yo tricks and we'd all rush out immediately to buy Coca-Cola yo-yos. No other yo-yo would do. They had to be the Coca-Cola ones. It was a brilliant marketing gimmick. Every kid in the school was flashing around the logo while trying to perform the yo-yo tricks. Coca-Cola repeated this type of campaign all around the world for decades. In 1960, the campaign went to New Zealand. Coca-Cola made a contract with Hammer and Barrow, who were to manufacture the yo-yos. They were to supply 200,000. The first batch of 85,000 yo-yos were delivered to distributors in Auckland, who examined the products and found that almost all of them had problems. Many were the wrong colour, and many had been manufactured so poorly that the yo-yo would not move up and down the string. More than 80% of that first batch were defective. Coca-Cola tried unsuccessfully to communicate with Hammer and Barrow. From Coca-Cola's perspective, this was a dangerous situation because they had another 120,000 yo-yos on the way, and if those were defective as well, then their advertising campaign would be ruined and they would have a lot of useless yo-yos. Coca-Cola terminated the whole contract. Hammer and Barrow sued for damages. They accepted that the yo-yos had been defective, but they too had incurred losses, including the costs of manufacturing the tens of thousands of other yo-yos they had underway. The question before the court was whether Coca-Cola had the right to cancel the order for the other 120,000 yo-yos, which might have turned out okay. In other words, could they terminate the contract for an anticipatory breach, a breach that had not yet actually occurred? The court relied on earlier authority that in a contract like this, completed in instalments, the main tests to be considered are, first, the ratio quantitatively which the breach bears to the contract as a whole, and second, the degree of probability or improbability that such a breach will be repeated. In this case, the ratio was high, and the probability of further failure seemed almost certain. Coca-Cola was therefore entitled to terminate the contract in anticipation of Hammer and Barrow's further breaches.